Hi, my name is Father Anthony Saroki. I'm the pastor of Our Lady of Mount Carmel Parish in San Diego. This video actually is intended mostly for our parishioners, and I'm going to be talking a little bit about a recent Supreme Court decision issued on November 25th that regards religious liberty. For those of you watching who are not parishioners, you might be wondering what competence does a priest have to talk about these things? I readily admit I'm not an expert in constitutional law, but I did graduate from law school and practice law before entering seminary and becoming a priest. And I have been following with keen interest for many years the law, especially as it relates to religious liberty. So what we're talking about here is a recent decision of the Supreme Court, and the parties in the dispute were the Roman Catholic Diocese of Brooklyn, New York, who were the plaintiffs, and then the defendant, Andrew Cuomo, the governor of New York. And the Catholic Diocese was requesting that the court stop the government from enforcing certain restrictions on the number of people that could gather for religious services. So I have basically here, this is the actual decision available on the Supreme Court website, and I've highlighted certain passages that I'd like us to look at and talk about a little more. So you'll notice actually no justice has put their name as the author of this decision, and it's called per curiam. This just means that it's the decision of the court, and what it really means is the decision that a majority of the court, or 5 members, have issued, and that's what's binding, is what a majority of the court decides. So just the actual decision is that the respondent, in this case the government of New York, is enjoined, that is, they are prohibited from enforcing an executive order that limited attendance in religious services in certain parts of Brooklyn to 10 and 25 people. And you'll notice that this is a temporary situation, that the government is prohibited from enforcing this restriction while other legal issues are decided in the lower courts. There is a companion case brought by a synagogue, Agudath Israel of America. And what the court decides in this case involving the Roman Catholic Diocese of Brooklyn also applies, they say, to the case of the synagogue. So the Catholic Diocese and the Jewish synagogue were seeking relief. They were seeking help from the court regarding this executive order issued by the governor of New York. They have there, in response to the COVID pandemic, they've classified areas, geographic areas, by a color code, depending on the severity of the cases there, the number of cases there, like the positive cases of COVID and perhaps some other factors. And so in the red and orange zones, if an area fell under that, then the law stated that in the red, that no more than 10 people could attend a religious service, and in the orange, no more than 25. Okay. So the reason why the Supreme Court is getting involved is the claim by the by the Catholic Diocese and the Jewish Synagogue that these restrictions violate the free exercise clause of the First Amendment. So you know that the First Amendment of the Constitution, it says that government cannot, Congress can pass no laws restricting the free exercise of religion. So then there's a whole history of interpreting that. And so there's a little bit of a background. This is really important. The court notes that without contradiction from the government, that the Catholic Diocese here has complied with all public health guidance and additional precautionary measures as well. and that they have for months operated at 25% or 33% capacity without a single outbreak of COVID. So then the court here talks about what the standard is when a party is seeking an injunction, a preliminary injunction, while the rest of the case is sort of being worked through and decided. And so the decision here states that they are likely to prevail. In the end, when it's all decided, they're likely to prevail on the merits of the case. And if they're denied relief, there would be irreparable injury, and granting relief would not harm the public interest. So looking at sort of the merits of the case, is what New York has done, is it unconstitutional? Does it impermissibly abridge First Amendment rights? So in the analysis, again, this is a very brief analysis because this was a decision that was issued in a relatively short period of time. The restrictions are supposed to at least meet a minimum requirement of neutrality. And what that means is that restrictions on religious activities and secular activities basically have to be the same. That the religious activity can't be singled out for more restrictive treatment. And so the court says that, in fact, in this case, the houses of worship were singled out for especially harsh treatment. So talking about these red zones, for example, first the red zone, there are secular activities, businesses, which have been categorized by the government as essential and have no restrictions at all on the number of people they can admit into their buildings. The court goes on to list what some of these are. There was some testimony in the lower court, the district court, by a health department official that said, it admitted there's a large store in Brooklyn that could, quote, literally have hundreds of people shopping there on any given day. Also, too, there's an acknowledgement that there's been some COVID transmission that's happened in factories and schools, which have much less restrictions than places of worship. And so the court determines that the restrictions are not neutral, and so they must satisfy strict scrutiny. So this is important, very, very important in constitutional law. Strict scrutiny means that the government must have a compelling interest for its restrictions, and that the restrictions have to be narrowly tailored, very, very kind of laser guided, not overly broad, to achieve the compelling state interest. And oftentimes, once the court decides what level of scrutiny, so a lower level of scrutiny would be, for example, rational basis, in which the court will actually, the level of deference the court will give to the government action is really huge and wide, and really will only invalidate something on the basis of a rational basis test if the government is clearly acting for discriminatory purposes with discriminatory intent, or in just such an arbitrary way. So, and really, once the court has decided it's going to be strict scrutiny, in most situations, it will rule against the government action. So, did the government have a compelling interest? Yes, the court says. Stemming the spread of COVID-19 is unquestionably a compelling interest. But it is hard to see how the challenge regulations can be regarded as narrowly tailored. They are far more restrictive than any of the COVID-related regulations that have previously come before the court. So just let me stop here. During this pandemic, there have been two decisions the Supreme Court has made regarding First Amendment challenges on government regulations of religious activities. One of those cases early on in the pandemic involved a Pentecostal church in Chula Vista, actually not far from where I grew up. And one of the attorneys for that church actually is a parishioner here. And so I remember when that case was being prepared and when it was being argued before the Supreme Court, I had regular conversations with our parishioner. It's Paul Jonah, some of you know him. And In that case, the court decided by 5-4 to not grant relief to the church. In that case involved regulations in California that had a numerical cap of 100 people, no matter how large the building. And then the second case involved a church in Nevada, and the numerical cap there involved 50 people. In both cases, the court decided not to stop the government from restricting these things. And now the court has decided differently. Now, they do point out here that the restrictions in New York are more than they were in Nevada and California. However, it really doesn't actually explain the difference in the decision, because in those other two cases, there was 4 justices who would have granted relief in those cases. But they were in the minority at that point. So what changed? Most of you probably know. Justice Ginsburg passed away, and now Justice Barrett is on the court. And so that switched a 5-4 majority the other way in favor of the religious community seeking relief. That's really why those two cases turned out differently than this case. And so this is why this case really is significant, because it tells us how the court's going to decide things going forward. So yes, it was. New York's restrictions were especially severe, but we'll see there's more going on here, and the court's reasoning as to why it decides what it does could apply to even less restrictive regulations. Okay, so one thing that's very important, I think, is that, again, in the lower court, it was determined that there had not been any COVID-19 outbreaks in the diocese's churches since they reopened. They reopened for months. There was not a single COVID outbreak. In fact, the government praised the diocese's record in combating the spread of the disease. Court goes on to say that there are many other less restrictive rules that could be adopted. So when the court applies strict scrutiny, and the government says this is what we have to do to achieve this purpose, the court will come up and say, well, you could do this, or you could do this, and those things are less restrictive, and they still accomplish the purpose. So the court says here that, among other things, the maximum attendance at a religious service could be tied to the size of the church or synagogue. And it goes on to discuss how the 26 diocese churches affected are large. They can accommodate 500, even over 1,000 people. And so what I think the court is doing here actually is they're telling governments, if you're going to impose restrictions on religious services, the way you would do it is to have a limit of the number of people that's based on the size of the building. I'll talk later how that affects what's happening in California, right? So the idea is this: look, if a state says, you can't have more than 50 people at a religious service, regardless of the size of the building, right? That does seem a bit overbroad. I mean, what if the religious service is being held in a stadium, and you can still only have, let's say, 50 people or 100 people? It really doesn't make any sense. Now, going to the issue of irreparable harm. So basically, that if the court's saying if we don't act, then damage will be done that can't be fixed later. And indeed, what I really appreciate here is the court seems to have some sensitivity to the value of in-person religious worship, acknowledging that, while Catholics could watch Mass at home, they can't receive communion, and indeed there are important religious traditions in the Orthodox Jewish faith that require personal attendance. And then finally, in order to grant this relief, the court has to determine that in granting the relief, it will not harm the public interest. Now, this is where the court this is traditional language where the court acknowledges its limited competence, but then also why it has to assert itself more strongly when it comes to certain constitutional rights. So members of this court are not public health experts, and we should respect the judgment of those with special expertise and responsibility in this area. Even in a pandemic, though, the Constitution cannot be put away and forgotten. The restrictions at issue here, by effectively barring many from attending religious services, strike at the very heart of the First Amendment's guarantee of religious liberty. Before allowing this to occur, we have a duty to conduct a serious examination of the need for such a drastic measure. Now, there is a really important issue which the justices who dissented, all of them cited, and that is, so there was this classification of red zone and orange zone, and the lawsuit was brought, and then in the middle of litigation, the government removed those designations from those areas. And in fact, actually had a very, you might say, generous sort of occupancy limit in which they can have up to 50% of their maximum occupancy. And so since the government no longer had that restriction, one of the things that comes into play is this doctrine of mootness. So since this is no longer in effect, does a court really need to do anything now? Now the harm is no longer ongoing. And so normally that's what a court will decide, but there are exceptions to that. And that is when a harm could be repeated very easily, and to require a party to keep going back to court, filing new lawsuits every time the harm is repeated. If that's what would happen, that's an unfair burden to put on them. And so if there's something that could easily be repeated, a harm that can be repeated, the court often will say the matter is not moot. And indeed, that is the case in New York. The governor regularly changes the classifications of particular areas without prior notice, and the court has very sympathetic with the need for religious communities to be able to plan and to be able to in order to serve their members, right? And even if, for example, the court also sees it as harmful, even if missing just a week or two of religious services, the court thinks is harmful. So it's not enough, as the dissent says, to say, well, now these regulations are no longer in place. If they're reinstituted, just come back to us. That is, the majority opinion says that is not sufficient to protect these religious communities. Okay, so now this is the opinion of the court. These are the five justices have agreed to this, and so this is what really becomes kind of a controlling authority for other courts that are deciding similar matters that have been coming before them. This shows how the Supreme Court is going to address those if they come up on appeal. So I'm going to look very briefly at what are called concurring opinions, and then at the dissenting opinions. Just to, I should have said this probably at the beginning. So in the majority, you had Justice Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Okay, and then some of those in the majority also wrote what's called a concurring opinion. So in which they basically want to say more about the issue. Maybe they want to elaborate on an analysis of things, or even so beyond sort of the consensus of the per curiam opinion, there's other points they want to make, and so these can be helpful if you're thinking about how a case with some different facts, how that might be decided. It can be helpful to look at concurring opinions to kind of have a sense of where specific justices stand on things. So Justice Gorsuch has a concurring opinion. It's a very vigorous defense of First Amendment rights, and that these can't just be suspended because there's a public health emergency. And he makes a big point about how the governor chose to impose no capacity restrictions on certain businesses he considers essential. And he goes on to say, who knew that public health would so perfectly align with secular convenience? And he goes on to talk about various areas that people can gather inside for extended periods of time without any government restriction, and whereas the religious communities in their own buildings are restricted. So I think this has been something. If you look at opinions on Twitter, some people have criticized Justice Gorsuch and said, well, a convenience store is different than a church. Convenience store people run in and out and things like that, whereas a church people gather for a while. They'll say people aren't singing in a convenience store, or they're singing in church, and those are all, I think, good points to think about. But also, the way I think about it too is, well, there certainly are many secular businesses in which people do congregate for a long period of time. Just think about going to a big store, retail store like Costco. People easily spend 30, 40 minutes in there. Well over 100 people are in the building at the same time, often passing each other closely in aisles, waiting not too far from each other in lines, and although they're supposed to be social distancing. So we see very clearly here there is a secular activity that is similar to the gatherings in churches that is not being restricted by the government. And interestingly, when it comes to the amount of time people are under the same roof, most dioceses in different ways have shortened the Mass. So, for example, in our parish, a Mass is only about 30-35 minutes long now. So that generalization of saying, well, no, convenience stores operate, or retail businesses operate this way and church operate this way, this generalization is not true across the board. And again, once you get into strict scrutiny, the government can't rely on generalizations like that. So that was a really important point. And then Gorsuch gets into this long discussion of a case that was cited in this South Bay Pentecostal Church, the case in Chula Vista, the California case that I mentioned. And I'm not going to go into too much, except that Gorsuch is very critical of the opinion that John Roberts wrote in that case, and Justice Roberts' citation of a 1905 case called Jacobson v. Massachusetts, which involved a government requiring smallpox vaccines. And I think Gorsuch is right. There's reasons why Jacobson doesn't apply in these cases. These cases involve a different right, specific First Amendment right, and there's all kinds of other distinctions. So interestingly, when we get to Justice Roberts' dissenting opinion, he really tries to defend himself against Gorsuch's critique, and it seems like there's some real tension between those two justices. I think okay. So we'll look at Roberts in a little bit. Kavanaugh has a concurring opinion as well. And again, he emphasizes this idea about the numerical caps not applying to secular buildings in the same neighborhoods as they apply to church buildings. This is a really actually stunning statement here, especially as in a moment I'll explain why, because I'll just explain briefly the dissent's rationale. He says, but under this court's precedents, it does not suffice for a state to point out that as compared to houses of worship, some secular businesses are subject to similarly severe or even more severe restrictions. So what's going on here? If you look at Sotomayor's dissent, and I think maybe Breyer's to a lesser degree, they rely on these two earlier cases that I talked about, and in those two earlier cases, the majority at that time found that the restrictions on houses of worship were neutral, and the way they reached that conclusion is they said, well, worship is like going to a movie theater, or gathering for worship is like going to a concert hall. And because, for example, the state of California has has severely restricted theaters and concert halls, so also it can do so for churches. Okay, so but now there's a 5-justice majority that just rejects that, this sort of concert halls, theaters, churches, and says you have to look broadly at secular businesses. Okay, I'm going to briefly, I just chose to highlight a couple things. The most important thing is that whole per curiam decision, which we went through. So Roberts now is dissenting, and he dissents primarily on the issue of mootness. He says these restrictions no longer apply. The applicants can gather up to 50% capacity, and so I wouldn't decide this now. I would wait and see if the government reimposed the more severe restrictions, and then Roberts is defending himself against the critique of Corsi, basically saying I didn't rely on Jacobson as much as you say I did. Now you have Breyer, Sotomayor, and Kagan. This is a dissenting opinion authored by Breyer. And then Sotomayor and Kagan have a separate dissenting opinion as well. This one focuses on the issue of kind of mootness, actually. But then the other dissenting opinion, keep scrolling, sorry. This is Sotomayor and Kagan. Okay, so again, they cite these previous 2 cases, and they say similar or more severe restrictions to comparable secular gatherings. So this is, to me, the big change that's happened. No longer can the government say, well, spectator sports, concerts, movie showings, see, we're restricting those just like we're restricting churches, so there's no discriminatory effect here. That seems to be something they won't be able to rely on. So where do I think this puts us here in California? So I think that actually, so right now in San Diego County, we are, it's a different color system, but we're what's called the purple tier, and we are prohibited from having any religious gatherings indoors. I think under the reasoning of this Brooklyn versus Cuomo case, I think that is unconstitutional for the state of California to prohibit us from gathering indoors. Similarly, when we are under the red tier, we could gather indoors, but there was a numerical cap of 100 people, and I think those are disfavored now by the court, and because they're not connected with the size of the building. So what I actually think is if the court probably would accept if the government had an actual percentage of maximum occupancy. They kind of have actually already they suggested that that could be permissible, which is very interesting for us because before we resumed public worship back in, well, June we resumed it, but we were talking about all through May. We had developed a plan which would have people being able to gather, but 6 feet apart between households and wearing masks. And based on the size of our church, it's a very large church, it would mean basically between 275 and 300 people could be there at once and be socially distanced. And then that's what we had planned for, and then the government said that we couldn't have more than 100 people. So I certainly would like to see the numerical cap lifted. A lot of people are very fearful. They think, oh, all these religious people are going to be, crowding in together into these churches and for hours and singing and getting everybody sick. That really isn't what's been going on. You might find a few places of very small religious communities that are not taking precautions, but that is not what's happening, certainly throughout the Catholic world. And for us, it would certainly be an improvement to be able to have people gather indoors, again, even though socially distanced and wearing masks. We could have our daily masses certainly indoors and some of our weekend masses, as well as weddings and funerals. I am hopeful that there will be a brave California bishop who will challenge these California restrictions I think that they are, based on this decision in Brooklyn v. Cuomo. The current restrictions are unconstitutional. I think certainly for us, we've been having a lot of service outside. We have a pretty good setup for that, but that isn't the case everywhere and won't be the case always, right? So there'll be certainly parts of the state in which, just in our diocese, you go to Julian and it gets freezing cold. It's not really practical for people to gather outside. In any ways, it really isn't up for the government, I don't think, to tell us that we can't use our buildings at all, especially while they're telling secular businesses that they can use their buildings. And as much as, again, we have a nice outdoor setup here, in Catholic theology, the church building is very important. We consecrated this building, every aspect of it, the altar, the ambo, where the people sit, where the choir is, the art, the verticality, all this has deep meaning. The church building is an icon of the church herself. And so I am hopeful that we will, in part based on what just happened in this New York case, that we will be able to return to indoor worship with those reasonable precautions that we already would do anyways, absent from any government restriction. So in any event, I hope you've found this helpful. I did just put this together fairly quickly, so that I know it's a topical, timely thing, and some of you might be looking for a perspective on this. And so I hope you found this helpful. May God bless and keep you.